In the case of medical marijuana, Inc. v. Horn, the Supreme Court looked at whether people can get extra damages for business or property losses, even if those losses started with a personal injury. The law in question is called RICO, which is usually used to fight organized crime, but it can also be used in civil lawsuits. Nine Robes uses non-partisan, everyday language to focus on the facts of what the Supreme Court is saying. Here, you'll find clear, concise summaries of every Supreme Court opinion, stripped of legalese and clickbait headlines. Each post breaks down the facts, explains the court's reasoning, and highlights the crucial details that often go unnoticed. It's not just about what the court decided, it's about why those decisions matter, to give you a deeper understanding of the cases that define our nation's legal landscape. These summaries are generated by AI. Be careful and consult reputable sources when in doubt. The court decided that if someone loses money or property because of something that started as a personal injury, they can still ask for triple damages under RICO. This goes against what some lower courts had said before, which was that you couldn't get these damages if your business or property loss was tied to a personal injury. This decision could change how some lawsuits are handled, especially when business losses are connected to personal injuries. Douglas Horn, a long-haul truck driver, began using Dixie X, a cannabidiol (CBD) tincture marketed as THC-free by Medical Marijuana, Inc., to treat chronic pain. After a workplace drug test detected THC, Horn was fired and sued under the Racketeer Influenced and Corrupt Organizations Act, RICO, alleging that medical marijuana's misrepresentations constituted mail and wire fraud predicates. The district court granted summary judgment for medical marijuana, holding that Horn's lost employment flowed from a personal injury, the ingestion of THC, and that Statute 1964C forecloses recovery for personal injuries or for business or property losses derived from them. The Second Circuit reversed, 80 F. 4th 130 2023, holding that 1964C authorizes treble damages suits for business or property losses even if they derive from a personal injury, and adopting a broad definition of business to include employment. The Supreme Court granted certiorari to resolve a split among the circuits over whether RICO bars suit for business or property harms that result from personal injury. Justice Barrett, for a 5-3 majority, addressed whether civil RICO categorically bars recovery for business or property losses that derive from a personal injury. Relying on the ordinary meaning of injure, to cause harm or damage to, she held that Fact 1964C plainly authorizes suits by any person injured in his business or property, implicitly excluding personal injuries but not business or property harms that stem from them. The majority rejected petitioner's term of art argument that injured requires invasion of a legal right in business or property, observing that context favors the ordinary definition and that damages must mean monetary redress, not harm. It found support in civil RICO precedent to import a common law situs rule into Section 1964C. Antitrust precedents construing identical language in the Clayton Act, Section 438 Stat 731, do not govern RICO. Finally, the majority stressed that RICO's other limits, its proximate cause requirement and pattern element, mitigate any over-federalization, and it left further policy refinements to Congress. Justice Jackson concurred, emphasizing that Congress directed in Section 904A, 84 Stat 947, that RICO shall be liberally construed to effectuate its remedial purposes. She argued that a broad reading of the statute's private action provision is especially warranted given RICO's remedial design and its civil provision's purpose of enabling private enforcement of racketeering prohibitions. Justice Thomas, joined by no other justice, would have dismissed the writ as improvidently granted. He argued that we cannot know whether Horn suffered a personal injury because the district court and parties disagreed below. He urged resolution of that threshold issue first and contended that no party fully briefed the definition of injured in his business or property. Justice Kavanaugh, joined by Chief Justice Roberts and Justice Alito, dissented on the merits. He maintained that injured is a term of art importing the tort law definition, the invasion of any legally protected interest, and that RICO's text, modeled on the Clayton Act, precludes personal injury suits. Lost wages and medical costs, in his view, are merely damages flowing from a personal injury, not distinct business or property invasions. When Congress added BARC 1964C in 1970, it deliberately limited private RICO actions to persons injured in their business or property, implicitly excluding personal injuries. In American tort law, injury denotes the invasion of a legal right, personal, property, or business, distinct from the economic damages a victim sustains. By contrast, the majority reads injured in its ordinary sense, harmed or damaged, allowing recovery for business or property harm regardless of its source. This interpretation subverts RICO's text and historic tort categories, which this court and earlier antitrust decisions recognized when construing the identical injured in his business or property language. The statutory choice of the disjunctive business or property, not and, its modeling on Clayton Act Beck 4, and the placement of damages as separate relief for approved injury all underscore that Congress did not intend to federalize garden-variety personal injury torts simply because they yield lost wages or medical expense damages. Find us online at 9robes.ai. That's the number, 9robes.ai. Like and share this podcast with friends that like to be informed. 9 Robes provides AI summaries of U.S. Supreme Court cases. AI makes mistakes. People make mistakes too. We genuinely do our best to provide you with the most accurate summaries, but our best sometimes includes errors.